Welcome back, dear students. Today we will start Unit 3. This unit mainly relates to the drafting of applications for bail in billable offenses, in non-billable offenses, and an application for anticipatory bail also. So today we are going to start with drafting of application for bail in these three categories. Dear students, before we dwell upon the actual drafting of application for bail, let us understand what is bail and what is remand. You see, whenever an accused person is arrested and detained by the police during investigation, and it appears that investigation cannot be completed within 24 hours as fixed by Section 57 of CRPC, and there are grounds for believing that accusation or information is well founded, the accused person has to be forwarded to the nearest judicial magistrate for remand, along with copies of case diary and journal diary, according to Section 167 of CRPC. And the magistrate to whom the accused was so forwarded may from time to time authorize the retention of the accused either in police custody or in judicial custody. So remand is of two types. One is judicial custody remand, that is sending a person to jail like Tihar jail, or remanding the accused in police custody, that is handing over of the accused to the police for further investigation. And dear students, normally in serious cases, it is very difficult to complete investigation in 24 hours. So remand has to be given by the magistrate on the application of investigation officer. But there are certain offenses in which investigation can be completed within 24 hours. Like you were driving your car without seat belt, you are caught in the camera. So investigation is over. Your offense is visible. There is no need of forwarding the accused to the magistrate because you have completed the investigation within 24 hours, or say within 5 minutes or 2 minutes, the investigation relating to traffic offenses can be completed. Or suppose somebody is keeping illegal revolver in his possession and he is arrested by the police and revolver is recovered from him. So almost offense is made out that you are in possession of revolver without license. So investigation can be completed even before 24 hours. But in serious offenses like theft, murder, rape, robbery, dacoity, cheating, and other frauds, especially nowadays the cyber frauds, it may take more than 24 hours for completion of investigation. And if the accused is arrested in between, then it is a duty of the police to produce that accused before the nearest judicial magistrate for looking into the legality of further detention, if any. You see, this Christian Michael accused who was extradited from UAE, he was given 5 days CBI remand initially. So CBI remand here means equivalent to police custody remand, because it may be CBI remand, it may be NIA remand, depends upon the investigating agency who is investigating the crime. But dear students, this police custody remand can be granted only by the first class magistrate. Magistrate of second class cannot grant police custody remand unless he is authorized by the concerned High Court. And any magistrate can grant remand of an accused person. Even executive magistrate like SDM, he is also authorized to grant remand for 7 days in the absence of judicial magistrate. If judicial magistrate is not available in the district, none of the judicial magistrate is available, then remand can be granted by SDM also. You know this gangster Vikas Dubey. His remand was granted by CJM Ujjain in Madhya Pradesh, where Vikas Dubey was arrested although all his cases against him were pending in UP. So Ujjain magistrate had no jurisdiction to try the cases, but still according to CRPC, he has jurisdiction to grant remand. So the remand was granted in Ujjain. Later on, Vikas Dubey was killed in an encounter when he was being brought from Ujjain to the court concerned in UP. But dear students, this police custody remand has a maximum limit of 15 days. Maximum police remand in first 15 days of arrest can be granted. And if further detention of the accused is necessary for the purpose of investigation, then police may ask for further remand and the magistrate may grant further judicial remand for a maximum period of 15 days again at a time. But the total period of detention shall not exceed. There are two categories. Total period of remand, including the police custody remand, shall not exceed number one, 90 days if the offense is punishable with death or life imprisonment or for a term not less than 10 years. So in all offenses which are punishable 10 years or more, extending up to life imprisonment or death, maximum remand period is 90 days, that is 15 into 6. 15 into 6 is equal to 90 days remand can be granted if the investigation is not completed and accused is in custody. Second category, that total period of detention shall not exceed 60 days in offenses punishable with a term of less than 10 years. And on expiry of this period of 90 or 60 days, the accused person shall be released on bail if he is prepared to furnish bail. This bail is equivalent to bail under Chapter 33 of CRPC. We call it default bail. If investigation is not completed within period of 90 or 60 days, then accused is entitled to bail and then investigation may go on for any number of days. This is for the protection of personal liberty of the accused and a pressure on the police or CBI or any other investigation agency to complete the investigation as early as possible. Then I told you that executive magistrate is also empowered to grant remand for 7 days where judicial magistrate is not available. So executive magistrate or metropolitan magistrate should have been conferred power to grant remand by the High Court. And after 7 days, accused has to be produced before judicial magistrate from jail. He has to be produced before that magistrate. He has jurisdiction to try the offense. And judicial magistrate can authorize further detention of the accused up to total period of 90 or 60 days. Then there is one more provision in the CRPC, that is order of stopping investigation beyond 6 months in summon cases which are triable by magistrate. You see, summon case is a very petty case. And if in petty case, the police could not complete investigation in 6 months, then better it is to stop the investigation. So in summon cases, if the investigation is not completed in 6 months from the date of arrest of the accused, the magistrate shall make an order stopping further investigation into the offense, unless the investigation officer satisfies the magistrate for special reasons and in the interest of justice, continuation of the investigation beyond 6 months is necessary. And session judge can reverse the above order in his revisional jurisdiction. The Court of District and Session Judge is an appellate as well as a revisional court so far as the orders of magistrate are concerned. Now, coming to the bail. The idea behind arrest and detention of the accused persons is to secure his attendance at the time of the trial. and to ensure that if he is found guilty, he is available to receive the sentence. If his presence can be procured before the court otherwise than by arrest and detention, then concept of personal liberty demands that the person should be released on bail. But bail, my dear students, is nowhere defined in CRPC. Bail is to procure the release of a person from legal custody with an undertaking that he shall appear at the time and place designated and submit himself to the jurisdiction and judgment of the court. This is the total purpose of bail. You see, when a person is accused of a serious crime and is likely to be convicted and punished for such a crime, and chances are that he will abscond or he will jump bail. If such person is arrested, it is not desirable to grant him bail and restore his liberty. Similarly, if the arrested person, if released on bail, is likely to tamper with the prosecution witnesses and obstruct in the conduct of the trial, or is likely to commit more offenses during the period of his release on bail, it would be improper to release such person on bail. On the other hand, where there are no such risks involved, the person should be released on bail. The cardinal principle, my dear students, is the bail and not the jail. That should be the rule, because the accused is presumed to be innocent unless and until proved guilty. Hence, it would be unjust to keep him in jail before his guilt is proved. The law of bail, truly speaking, has to balance out between the individual liberty of the accused and the liberty of the society in the sense of the protection of the society. My dear students, you will see that CRPC has classified all offenses into bailable and non-bailable as per schedule attached to it. And if you make an analysis of this schedule, the analysis of this schedule shows that all serious offenses, that is offenses punishable with imprisonment for 3 years or more, have generally been classified as non-bailable. Though there are exceptions to this rule also. But generally, offenses punishable with punishment of 3 years or more are designated as non-bailable offenses. And if a person accused of bailable offense is arrested or detained without warrant, he has the right to be released on bail. But if the offense is non-bailable, then it does not mean that person accused of such offense shall not be released on bail. But in such cases, bail is not a matter of right, but it is a matter of discretion of the court only. In bailable offense, it is the right of the accused to get bail, but in non-bailable offenses, it is a discretion of the court whether to grant bail or not. Now, dear students, with this background knowledge in mind, we will start learning the drafting of a bail application in bailable offense. So first of all, you will have to check from CRPC or the law under which the person is arrested, whether the offense is bailable or not. An offense under Section 60 of Excise Act is bailable. An offense under Section 13 of UP Public Gambling Act, playing cards at public places, is also bailable. And there are so many other laws having bailable offenses. And CRPC also classifies IPC offenses into bailable and non-bailable offenses. So first of all, dear students, you are supposed to select the name of the court. And of course, name of the court has to be selected from the hierarchy of the court, and lowest court has to be selected for moving and bail application. And this bail application shall be moved in the court from where the accused was remanded to judicial custody. So name of the court here is in the Court of Judicial Magistrate Class 1, Noida. District Gautam Buddha Nagar, UP. Then you are supposed to mention criminal case number whatever is the number, say 234 of 2020. This case number means the case serial number at which the case is registered in the record of the court. Now you will write down the name of the parties. In criminal cases, one of the parties is always a state. So state of UP versus name of the accused. Accused is A, son of B, aged about 40 years, resident of flat number 918, Pavilion Court 10, JP Greens, Fishtown, Sector 128, Noida, Gautam Buddha Nagar, UP. So name parties you have drafted. Now you will write down the crime number. Crime number means the crime number allotted by that particular police station in whose jurisdiction the accused was arrested. FIR number is separate, crime number is separate. So here the crime number is 45, say, of 2020, and the section under which you are seeking bail under section 60 of UP Excise Act 1910. So you will write down the crime number as well as section under which you are asking the court to grant you bail. Then center heading, application for bail in bailable offenses. You will write down in the bracket under which section you are seeking bail. That is section 60 UP Excise Act 1910. Then you are supposed to write down that accused A is in custody, because bail presupposes custody. You cannot move bail application unless the accused is arrested. Exception is anticipatory bail. We'll come to that also very shortly. Now the opening sentence which you are supposed to draft will be like this. The accused applicant most respectfully submits as under. Now the facts are to be written in short paragraphs, and all these paragraphs shall be numbered consecutively 1, 2, 3, 4. So para 1. That on the midnight of 1st January 2020, the police of Sector 62 Noida visited the residence of accused and arrested him when he was sleeping in his house. This is fact number 1. 2. That the police forcibly took away the accused in their jeep around 3 a.m. in spite of resistance of his family members. Brother of A sent an email to Superintendent of Police same night at 3:30 a.m. regarding whisking away of A by the police. So here you are hitting that he was wrongly arrested from his residence when he was sleeping. So his brother sent email also to the Superintendent of Police. Para 3. That the police has now planted 2 bottles of illicit liquor and shown them as recovered from the possession of the accused. This is the fabrication by the police, according to accused. Para 4. That the place of arrest of the accused is wrongly shown as near metro station, Sector 62 Noida, whereas he was arrested from his residence. So this is the contradiction. Para 5. That the accused was sent to jail on 2nd January 2020 by remand order of this honorable court. So remand was granted by this court before which you have moved this bail application. Para 6. That the offence under section 60 UP Excise Act is bailable one. Yes, I was telling you that offense under section 60 of UP Excise Act is bailable, and this is sufficient ground for sanction of this bail application, granting of this bail. Para 7. That the accused is entitled to bail and is ready to furnish bail. Para 8 is the prayer. It is therefore most respectfully prayed that the accused may kindly be released on bail during pendency of the trial. You will draft the place where this application was drafted, that is Noida, Gautam Buddha Nagar, and date also, 3rd January 2020. See, on the first midnight, he was arrested. On 2nd January, he was sent to jail. And very next day, 3rd January, you are moving an application for bail in billable offense on behalf of accused A. Since accused is in jail, so this bail application has to be moved by some counsel or advocate. So you will write down through counsel ABC. Then signature of ABC advocate are also required. Accused cannot sign this bail application because he is sent to district jail and he is not available for signing this bail application. Dear students, please take note of this fact that when accused is in jail, who will engage the lawyer? Accused cannot come out from the jail unless he is released on bail. Very obvious that some family friend or member of the family will go to a lawyer and will sign his memorandum of appearance. So here in this case, memorandum of appearance on behalf of A, son of B, is signed by B, which is being filed along with this bail application. B is the father of A. When son was arrested, so father approached the advocate, paid him the required fees also, and then he drafted the bail application. And secondly, you should note, dear students, that no court fees is payable on bail application. Like in a civil case, you are supposed to pay court fees on your plaint. But here on criminal side, if the accused is in jail, then no court fees is payable on bail application because it is a question of personal liberty of the person who is detained, that for restoration of his personal liberty, he should not be asked to pay the court fee. That should be free of cost. And third, it is the right of the accused to get bail in bailable offenses. So single ground is enough that the present offense is bailable one. That's good enough. But you will have to write down the story as to when accused was arrested, when he was sent to jail, how many days he is in custody, and the date of moving this bail application also is to be mentioned in this bail application. So this is very short drafting, very small drafting, so far as application for bail in bailable offenses is concerned. Now we moving on to bail in non-bailable offenses. As I told you that in non-bailable offenses, it is not the right of the accused to get bail. If you see column 5 of the schedule 1 attached with the CRPC, this column 5 classifies all IPC offenses into bailable and non-bailable offenses. As I told you, that bailable offense means an offense which is shown as bailable in the first schedule or which is made bailable by any other law for the time being in force. Like UP Excise Act section 60 says that offense is bailable. Section 13 of UP Public Gambling Act says that offense is bailable. And a non-bailable offense means any other offense which is not shown as bailable in the schedule. And the significance of this distinction is that in bailable offenses, accused has a right to get bail under section 436 of CRPC, while in non-bailable offenses, it is a discretion of the court whether to grant bail or not under section 437 of CRPC. Now, this new CRPC of 1973 has also provided a provision for anticipatory bail to a person apprehending arrest for a non-bailable offense in view of section 438 of CRPC. My dear students, here are 3 equations before you. Suppose in one group of offenses, one section is bailable and other section is non-bailable. So bailable plus non-bailable offense will be equivalent to non-bailable offense. Suppose in a case of murder and screening away the evidence for crime, section 302 and 201 IPC. So 302 murder is non-bailable, whereas 201 causing disappearance of the evidence of the crime is a bailable offense. But when police has fixed an accused person under section 302 read with 201 IPC. So 201 is billable, 302 is non-billable, but offense in totality will be non-billable. Similarly, if one of the offense is cognizable and second offense in the same group is non-cognizable, so in totality, the total offense will be treated as cognizable offense in view of section 155, clause 4 of CRPC. And likewise, if in a group of offenses, one offense is compoundable and others are non-compoundable, then in totality, the offense shall be treated as non-compoundable. So accordingly, you will have to move bail application. Why? The reason is that major offense in a group will decide the nature and gravity of the offense. So major offense is obviously in first equation non-billable offense. In second equation, major offense is cognizable offense. And in third equation, the major offense is non-compoundable one. So the result is non-billable, result is cognizable, and result is non-compoundable, so far as these three equations are concerned. So dear students, now with this background knowledge in mind, we will start learning the drafting of a bail application in non-billable offenses. You will have to see section 437 of CRPC 1973. Now, first of all, the name of the court is to be selected. Name of the court shall be selected according to the offense committed by the accused. The present illustration which I have taken before you is the name of the court is in the Court of Session Judge, New Delhi. That means either the cognizance is taken by the session court himself, or the case has been committed to the Court of Session by the judicial magistrate or metropolitan magistrate. Had it been committed to the Court of Sessions, again you are supposed to move bail application first before the trial court, that is metropolitan magistrate. If he rejects the bail application, then you can go to the session judge also. But here the offense is under section 21, 61 and 85 of Narcotic Drugs and Psychotropic Substances Act. These offenses are directly triable by Court of Session. And the remand is also granted by the session judge himself. So first of all, the name of the court you have drafted. Then in bail application, you can write down the name of parties like this also: accused at serial number 1 versus state at serial number 2. But if you are writing state versus A, then you will have to give a center heading: application for bail on behalf of A. But you can write like this also: A son of B, resident of flat number 437, Designers Park, Sector 62, Noida, Gautam Buddha Nagar, UP. You see, I have highlighted flat number 437 with bold letters, just to remind you that this is an bail application moved under section 437 of CRPC and the offense is non-bailable. So after mentioning the name of the parties, you will write down FIR number. FIR number is allotted at the police station itself the moment FIR is registered. So your FIR number, say, is 7 of 2017. Then under which section the FIR was registered? That is 21/61/85 of Narcotic Drugs and Psychotropic Substances Act. At which police station this FIR was registered? Police station is Connaught Place, New Delhi. Then the opening line to be drafted for the court respectfully is: the accused above named most respectfully sheveth as under. Now what are the facts? Para 1. That the accused above named was arrested by the police on 1st January 2017 and is in judicial custody since then. It is alleged that on 1st January 2017, accused was suspiciously going on Baba Khadak Singh Marg, New Delhi at about 2:30 AM when police arrested him and conducted his search. and recovered 3 grams of smack from his pocket. Smack is a narcotic drug. So this is the story enacted by the police that on 1/1/2017, accused was suspiciously going on Baba Khadak Singh Marg, New Delhi at about 2:30 a.m. So night patrolling police arrested him and conducted his search and recovered 3 grams of smack from his pocket. Para 2, that the accused has been falsely implicated in the instant case and he has nothing to do with the alleged offense. This is a denial which you have drafted in this bail application. Para 3, that nothing was recovered from the possession of the accused. The so-called case property has been planted upon the accused by the police. Again, denial. You are denying that you have not committed any offense. Para 4, that the accused is a law-abiding citizen and belongs to a very respected family. He has never been indulged in any illegal activities and he commands respect and admiration in the society. This you are showing your good characters. All right. Para 5, that in November 2016, the accused A found that X, Y, and Z were selling smack near Hanuman Mandir, Connaught Place, New Delhi. And the accused immediately reported the matter to the police. As a result of which X, Y, and Z were arrested by the police. Since then, X, Y, and Z were threatening the accused to falsely implicated him in a criminal case in collusion with the police. This is the reason which you are telling why you have been falsely implicated, because you got arrested X, Y, Z who were doing the illegal business of selling smack near Hanuman Mandir, Connaught Place, New Delhi. So out of revenge, you are saying that because of this revenge, you have been falsely implicated. Stories invented and drafted by XYZ in collusion with the police. Para 6. The accused had made a complaint to the Deputy Commissioner of Delhi against X, Y, and Z on 25th December 2016. You are showing what you had done and why you have been falsely implicated now. So you accused says that he had made a complaint to the Deputy Commissioner of Delhi against XYZ on 25th December 2016 and true copy of the said complaint is enclosed herewith as Annexure 1 with this bail application. Para 7, that after the said complaint of A, he was called by the Vigilance Department of Delhi Police. The true copy of the said notice issued by the Vigilance Cell is enclosed herewith as Annexure 2. Para 8, that it is unimaginable that the accused who made complaint against the seller of the smack would himself indulge in such illegal activities. You are saying that I am a law-abiding citizen and I got XYZ arrested who were selling the smack. So why should I sell the smack? And why should I indulge myself in illegal activities? Para 9, that the accused is a permanent resident of Noida and there are no chances of his absconding in case he is released on bail. And this is a good ground of bail, that a permanent resident of a particular place, there are little chances of absconding. Para 10, that there are no chances that the accused will tamper with prosecution witnesses in case he is released on bail. You are giving a promise and saying that there are no chances that I will tamper with prosecution witnesses if I am released on bail. Para 11, that the accused was arrested from his residence at Noida when he was sleeping in the morning of 2nd January 2017 and was produced in the court for remand. So you are denying the police story that you were suspiciously wandering on Baba Khadak Singh Marg at 2:30 a.m. And your plea is that you were arrested from your house in Noida when you were sleeping in the morning of 2nd January 2017. Para 12, that the accused will cooperate in the investigation as and when called upon by the police. Yes, this promise will lead you towards grant of bail. Para 13, that the accused is not a previous convict and has not been involved in any case till date. Dear students, it is mentioned in section 437 that if accused has a criminal history, he should not be released on bail. So you are giving a promise that you are not a previous convict. There is no criminal history. Para 14, that the present case is a result of clear manipulation by the police. Yes, you have narrated the facts which are indicating that case has been manipulated by the police. Para 15, that the accused is an innocent person and there is not an iota of evidence against him in the case diary of the police. This is the most hitting and important ground of bail, that there is not an iota of evidence against the accused in the case diary of the police. Para 16, that section 50 of Narcotic Drugs and Psychotropic Substances Act 1985 was not complied with by the police, since the accused was not produced before a gazetted officer for his search. This goes to show that police has falsely implicated the accused. You see, this is a legal requirement of the Act according to section 50, that if a person is arrested in suspicious circumstances and police has reason to believe that something illegal may be recovered from the possession of the accused, then accused should immediately be produced before a gazetted officer. And his search should be taken in the presence of gazetted officer. And police has failed to comply with section 50 of NDPS Act. So this goes to show that police has falsely implicated the accused. Para 17, that because of non-compliance of section 50 of NDPS Act 1985, accused deserves bail in view of several rulings given by the Supreme Court. Yes, Supreme Court has said so many times that if a person is arrested under Narcotic Drugs and Psychotropic Substances Act without producing him before a gazetted officer, then he is entitled to bail. Para 18, that no independent witness was called at the time or after the arrest and before the search of the accused. This is the provision of CRPC section 100, that whenever a person is arrested and police wants to make search, so that search should at least be conducted in the presence of two independent witnesses. So this was also not done by the police. This is another ground for bail. And para 19, that the accused is ready to furnish the sureties to the satisfaction of this honorable court for his appearance before the court during the trial. This assurance is also to be given by you, that you are ready to furnish the sureties. And lastly, the prayer. It is therefore most respectfully prayed that the accused may kindly be released on bail during pendency of this case. Why during pendency you are asking bail? Because at the close of the trial, if you are acquitted, there is no need of asking bail further. If you are convicted, you will be taken in custody. Then you can move the same bail application before appellate court, where you will file appeal against conviction order. So this is the prayer, that it is therefore most respectfully prayed that the accused may kindly be released on bail during pendency of this case. And this bail application is moved on behalf of A. Since A is in jail, so application has to be drafted and moved by some advocate. So you will write down through ABC advocate, who will put his signatures on this bail application. Place of drafting you will have to mention is New Delhi, and date of drafting is 7 January 2017. So dear students, this is how very shortly we have learned how to draft a bail application in a non-billable offense. Moving further, how to draft an application for anticipatory bail. Anticipatory bail you can apply under section 438 of CRPC. As I told you earlier also, that bail presupposes custody. If you are asking for bail, if you are moving an application for bail, this presupposes that accused is in jail. But there is one more exception now, that you can move bail application even if you are not arrested. you are likely to be arrested but not yet arrested. That exception is anticipatory bail. Anticipatory bail means bail in anticipation of being arrested. And this power of granting anticipatory bail lies with the Court of Sessions and High Court. Judicial magistrates, metropolitan magistrate, CJM, CMM, they have no power to grant anticipatory bail. So in the event of arrest, the accused is released on anticipatory bail if anticipatory bail was granted by the court. You see, what is the impact of grant of anticipatory bail? Offense must be non-bailable, because in bailable offenses, there is no need of moving anticipatory bail because offense is bailable. Whenever you will ask the officer in charge of police station or a criminal court, they will release you on bail. But if the offense is non-bailable, only then you will go for anticipatory bail. So if you are likely to be arrested in non-bailable offense and you have got an order of anticipatory bail, then non-bailable offense becomes equivalent to bailable offense. Because the language of anticipatory bail order is that in event of accused being arrested, he should be released on bail on his furnishing personal bond of say rupees 1 lakh and 2 sureties in the like amount. There is a direction from the session judge or direction from the High Court that in event of arrest, accused should be released on bail. So non-bailable offense has now been converted into bailable offense once you have the order of anticipatory bail in your pocket. And you must advise your client to keep the copy of the order of anticipatory bail in pocket round the clock, because whenever police will come to arrest you, you will have to show the copy of the order of anticipatory bail. And you should be ready with 2 sureties also. Sureties will have to show some document in order to give an assurance that they are solvent to the extent of the amount of bail bond, that is 1 lakh rupees or 50,000 rupees, as the case may be, as ordered by the court. Now we will start drafting an application for anticipatory bail. You will have to see section 438 of CRPC for that. So first of all, the name of the court is to be drafted. As you know that only session judges and high courts have power of granting anticipatory bail. So you will have to select the name of the court accordingly. And our name of the court here in this illustration is in the Court of Session Judge, New Delhi. Then anticipatory bail application number -- of 2017. You know the year in which you are filing bail application, but you do not know the application number which shall be allotted to the counsel whenever this bail application is filed in the court. Now you will write down the name of the parties. You can write the name of the accused at serial number 1, like A, son of B, aged about 20 years, resident of flat number 438, Designers Park, Sector 62, Noida, District Gautam Buddha Nagar, UP. You see here I have highlighted the word 438 with bold letters, so as to remind you that you have moved this bail application under section 438 of CRPC. And the second party is, of course, State of Delhi, State of NCT of Delhi. Then you will mention FIR number, say it is 71 of 2017. Then the section under which you are moving bail application, or the section under which FIR was lodged, is 307 IPC. Name of the police station where FIR was registered is PS Daryaganj. So you will have to write down FIR number, section of IPC or other laws under which you are arrested, and the police name of the police station where the FIR was registered. Now, center heading will be application for grant of anticipatory bail under section 438 CRPC 1973. The opening salutation addressed to the court will be drafted like this. The applicant named above most respectfully submits as under. Now you are supposed to write down the facts briefly into short paragraphs to be serially numbered like 1, 2, 3, 4, 5. So para 1. That the applicant is a young man residing at Designers Park, Noida. He is also director of Messrs ABC Limited, which is a leading company engaged in manufacture of electrical appliances. So this is the introduction of the accused. Para 2. That the applicant is a peace-loving and respectable person of his society. You are showing your good character. Para 3. That the applicant was on friendly terms with Miss Y, major daughter of the complainant. However, the relationship of the applicant with Miss Y was not liked by her family members, so much so that they had stopped Y from meeting the applicant and threatened her that in case she will meet applicant, they will implicate the applicant in some false criminal case. So family members of the girl, this is a role of the family members of the girl, that they have threatened that if she will meet the applicant who has now been arrested, then they will implicate the applicant in some false criminal case. The next set of facts are that Miss Y had also written a number of letters to the applicant calling up on him to marry her, as she had feared that her family members may sabotage her relationship with the applicant, which shows that family members of Miss Y were deadly against the applicant and were looking for some opportunity to falsely implicate him in some false criminal case in order to pressurize him to sever his relationship with Miss Y. Now, what are the actual facts which are mentioned in the FIR, para 5? That on 10 December 2016, the applicant had gone to meet his friend who is residing in the neighborhood of Miss Y. When the applicant reached near the house of his friend, he was suddenly attacked by father, uncle, and brother of Y, as a result of which he fell down and sustained injuries. The friend of the applicant came to the rescue of the applicant on hearing his cries. With great difficulty, the applicant was saved from the clutches of the family members of Y by other neighbors and passers-by. Next, that the police has registered a false FIR against the applicant. A bare perusal of FIR reveals that family members of Y attacked the applicant and not vice versa. Plaintiff has not beaten the complainant party. It is the complainant party who has beaten the applicant. In fact, the aggressors have connived with the police and have falsely implicated the applicant. The applicant is in fact a victim. Photostat copies of the letters written by Y to the applicant are annexed herewith. So applicant has a Majnun story. ये मजनू बेचारा पिट भी गया और इसके खिलाफ FIR भी हो गई. Thank God that he is not yet arrested. He is asking for anticipatory bail. Para 7. That the FIR registered against the applicant is absolutely false and incorrect. The applicant is not at all involved in the alleged offense. This is denial of the accused. Para 8. That there is not an iota of evidence in the police case diary against the accused applicant. This is a good ground. Para 8. 9. That the applicant apprehends that he may be arrested by the police in pursuance of the aforesaid false and fictitious FIR relating to attempt to murder. Charge of attempt to murder 307 IPC has been launched against this applicant. Para 10. That the applicant received 4 injuries on his body, whereas the complainant party received none of the injury, and they have not disclosed the manner of attempt of murder by the applicant. They have not explained the injuries on the body of the applicant, how a murder was attempted, how accused received 4 injuries, and none of the complainant party received any injury. This shows that the case is false. If accused has attacked them, they must have received some injuries. Para 11. that the applicant went to the police station for lodging his FIR same day and requested SHO Daryaganj for getting him medically examined. But neither his FIR was lodged nor his medical examination was got done. Since the accused was being beaten by the family of Miss Y, he went to the police station and requested SHO to register his FIR and get him medically examined. But neither his FIR was registered nor his medical examination was got done. Para 12. That the police officials have visited the residence of accused applicant in his absence, and there is every likelihood of being arrested in the instant case. Dear students, you must keep in mind that accused is not yet arrested, but there is likelihood of his being arrested in this case. Para 13. That the applicant undertakes to cooperate in the investigation as and when directed to do so. All right. 14. That the applicant is a permanent resident of Noida and there are no chances of his absconding in case he is granted anticipatory bail. Yes, this you are giving an assurance to the court that you will not abscond from the trial. Para 15. That the applicant is not a previous convict and has never been involved in any criminal case except the present one. You are assuring that you have no criminal history. Good ground. Now, lastly, the prayer. It is therefore most respectfully prayed that the accused applicant may kindly be released on bail in event of his arrest. See the portion in bold letters. May kindly be released on bail in event of his arrest, and appropriate directions in this regard may please be sent to the concerned investigation officer or SHO of PS Daryaganj and any other order or orders which this honorable court may deem fit and proper in the facts and circumstances of this case may also be passed. So your main relief is that in event of arrest, I should be released on bail, and necessary direction should be issued to the IU also that he should not arrest me. And if he has to arrest me, he should release the accused on bail immediately. So this bail application is moved on behalf of accused applicant A. Now you are not in the jail, so you are supposed to sign this bail application also. So accused will sign this bail application. And since this bail application has been drafted by ABC advocate, you will write down through ABC advocate, and advocate will also put his signatures on this anticipatory bail application. Place of drafting, you will mention New Delhi, and date of filing this application, say it is 1st April 2017. So dear students, this is how today we have learned 3 items. One is drafting of bail application in billable offenses. Number 2, drafting of bail application in non-billable offenses. And number 3, drafting of an anticipatory bail application. So thank you very much, dear students. God bless all of you.